it's so important to plan. And if we, fail to prepare, then prepare to fail. And if we really love your family or your loved ones, then a lot of people have a superstition about getting their estate planning done. They think if they do it, it sort of leads inevitable. But I think if you really care about what you've built and what you've got, and you want the right people to get it, then it's a form of love too.
Welcome to the Inspired to Thrive podcast. I'm your host, Phoebe Lay, and in each episode, I will be sharing with you insights from either an inspiring person or myself to help you thrive and shine online and in person. We talk about all things marketing, relationships, money, business, growth, mindset, and more. So thanks for tuning in, and I look forward to seeing you inspired to thrive. Welcome back to the Inspired to Thrive and Shine podcast. I'm your host, Phoebe Lay, and today we are diving into a conversation that could fundamentally change how you think about protecting everything that you have worked so hard to build. Now, before we begin, I want to be clear that today's discussion is purely educational and informational, and we are exploring general legal concepts and strategies today, not providing any personal, legal, financial, or tax advice. Every situation is unique, so please consult with a qualified professional about your specific circumstances. Now, let me introduce you to someone extraordinary. Peita Savage is the principal solicitor at HG Law Services in Sydney, and she's about to open our eyes to the legal foundations that most business owners and pre-retirees overlook until it is too late. Peita specializes in that crucial intersection where family law, business law, and estate planning meet. And she's seen firsthand how the right legal structures can protect decades of hard work, whilst the wrong ones can unravel everything. What I love about Peita's approach is that she doesn't just throw legal jargon at you. She makes complex structures simple, shares real stories that hit home, and most importantly, she understands that behind every legal document is a family, a dream, and a legacy worth protecting. So whether you're building your business empire, planning your exit strategy, or simply wanting to ensure your family's future is secure, this conversation will give you the clarity and the guidance to take action. So let's dive in. Peita, welcome to the show. It's so good to have you here.
Thank you so much for having me.
Peita, I talk to so many business owners who are pouring everything into building their businesses and building their wealth and their future for their families and also for the next generation. And today's conversation is, I think it's really important because some people treat things like estate planning like it's something for their parents' generation. And I wanted to find out, what is the cost of that kind of mindset? And could you share a little story about someone who thought their DIY was good enough and what actually happened to their family potentially?
Yeah, well, I actually do estate litigation from time to time, and that's really where wills and estate planning can get tested. And often people think that their situation is stock standard, they can just use a DIY kit or something they get from the post office. But the truth is, those template standard types of wills are not tailored to their specific situation. They don't have the right instructions on how to even execute the will properly. And very often, it's not till it's too late. So when the executors are applying for probate, that they realize the will hasn't been executed properly. There wasn't two witnesses, for instance, as an example I've seen in real life. And therefore, the court's not really bound by the document because it's not valid.
Wow.
So the alternative is applying for letters of administration, and then it's a court assessment about who is the right person to do that role, which can take a long time at court. And we can really upset day-to-day living expenses and needing the money from the estate to come through. So that's why we don't recommend people take that approach.
So I'd love to demystify, what's a testamentary trust and when does that make more sense than a standard will?
Okay, so testamentary trusts are one of the few structures that we have in Australia that allow, well, first of all, they're not a trust that comes into existence until you pass. So it's not as though you have to maintain the trust and spend accountants' monies on getting regular audits and tax returns done. It only comes into being once you pass, and it has some really unique features that other trusts don't have. I think it's really useful to families thinking about creating intergenerational wealth is it allows you to distribute the income from that trust to minors, and they don't attract the same tax as, say, family trusts might. So it's a really tax effective structure that you only can create once.
Wow, that's so interesting. At the moment, there are so many blended families now. I wanted to find out, what are the biggest legal landmines that you see that can help families navigate blended families, even divorces and separations with grace, and
Mm.
also with enough preparation?
One good thing about blended families, I think that maybe traditional couples might not have is that they've been through the family law process, which is in of itself, we could talk about that at another day, is quite painful. And so they sometimes come from families where perhaps one party brings more assets than the other, and those assets might have been sort of earmarked for their children rather than stepkids. I find like in practice, couples with blended families tend to think about those things a lot more carefully, wanting to respect their relationship and their marriage or whatever it might be, but also honor their kids from their previous relationship. So they might use their will to do that when they pass. So they might say, I might put these assets aside for my kids, and the assets that we've got together, we'll distribute between our family in a certain way. And that's why I think having open conversations with your family unit about these sort of things before it gets leads to conflict is a good idea. And your will can really tailor an outcome. A lot of people like to, in their will, use testamentary trusts to ensure that their assets go through the bloodline. So, to certain classes of beneficiaries, so only their kids and their grandchildren, maybe not stepkids. Or they might take another approach. They might regard their stepchildren as their own children and want them included too. There's no one way to do it, but yeah, it's an option. And also, the good thing about testamentary trusts, so circling back to those, is that if you set it up correctly, it does offer a lot of family law protections. So it can sort of insulate certain assets from litigation and outside creditors.
Is there a lot of cost involved in setting that up? If someone is listening to this and that they've already got their properties, maybe they're already in a long-term relationship with their spouse or their new spouse, and they're starting to think, okay, maybe I do want to set this up. Like, what are the costs that they need to consider? Is there things like stamp duty? What are some of the initial outlays they have to consider?
So the initial outlays for a will with a testamentary trust or multiple testamentary trusts, if you want to go down that path, it's only the drafting expenses. So they don't get stamped until they come to fruition. So when you pass, and then in our state in New South Wales, there's an exemption for certain things that arise from a will, and generally there wouldn't be stamp duty, and that's the beauty of having it created under the will.
So if someone passes away and their children inherit, say, a
Mm.
property, for example, are there like those types of costs, or does it protect them from having to pay a gifts tax or stamp duty, etc.?
There are certain things that are exempt from stamp duty, and usually gifts under will are those as long as they're distributed within certain time periods. Individual states are a little bit different, but in New South Wales, generally there's a 2-year limit. So if you do it within that window, it should be fine.
Okay, that's so very interesting.
But
So
it's
if
always changing. So it's one of those when a stamp duty and land taxes are always changing. And so it's always good to check.
Yeah, I think this conversation, obviously, you're based in New South Wales, I'm in Victoria. The listeners might be in different parts of Australia or the world. So, this is definitely one of those cases where it is important to get your own advice and to find out the information that's relevant for you.
Yeah.
So, moving direction here a little bit to asset protection, especially for people that are pre retirement, you mentioned that structures set early difficult to unwind later. Can you paint us a picture of what would too late look like and what is considered too late?
I think one thing that business owners especially sort of miss is that they don't take into account the fact that they might not always be well. They might not always have capacity. And it's true to say that in Australia we have like an aging population and not everybody loses capacity as they age, obviously. Some people continue to be as brilliant as when they were younger. But if you do lose capacity, you really need your business to get an order from the court or a tribunal to appoint a caretaker decision maker. And that would be a point where I say it's kind of too late. The costs are going to spiral if you get to that point. Whereas like, a simple strategy would be to have a corporate power of attorney drafted, and that's a simple strategy you can employ to make sure there's smooth transition. If you lose capacity, if you're overseas and decisions need to be made, that document can be used to for someone else to step in and do what needs to be done, like operate bank accounts, pay your employees, for example. Those sorts of decisions can be made by someone else. So I've seen that in real life that people have just never thought that anything would happen to them. They assumed they'd be bulletproof, and yeah, that's one area which I think people should pay a bit more attention to. Another thing I see is people don't get the right insurance. And if you're a one woman or one man operation, it can be a big error not to have the right business insurance in place to help your business if you're not there. Also, maybe have a look at if you're a company, your constitution. Can somebody be appointed in your absence? Or if you lack capacity, can someone replace you? Often, like when we set up a company, it could have been done 20, 30 years ago, and the Corporation Act could have changed since then. You might not cover that situation. There are some times I've seen some people with trusts they established in the 60s and 70s, and well, lots of things have changed since then.
Yeah, that's really important to look at for sure. And I think also a lot of business owners, when they first start out, they're not necessarily thinking so long term. They're holding their assets personally rather than through a trust or a company, for example.
Yes.
And then later on, when they start to grow and they start to gain more knowledge, they realize, oh, actually, maybe I should have held my assets through a trust or through my company. What is at stake if someone already owns property in their personal name and they're thinking, oh, it's too late, or maybe I've missed the boat? Like, what's at stake here if they don't have the right structures in place early?
Yeah, you're always exposed if you have your assets in your personal name to creditors, to being sued. So it's a good idea when you get to a certain point to transition so that one structure could be, say, going from sole trader to a company. So you can isolate and then separating your personal and your company assets so that you've got that extra layer of protection and putting your assets away from anyone that might want to come and take it. A lot of people neglect to do that, and they end up paying too much tax as well because there's different tax brackets for the different structures. So it's always good to get it reviewed, go see your tax advisor. Am I using the right structure for my business needs at that point? And
Mm.
sometimes, yeah, we get too busy, we're growing, everything's going well. It's not till things aren't well that you, you might realize, and yeah, we want to avoid that for people if we can.
Can you maybe peel back the curtain and explain to the listeners who don't understand what a trust is? They've heard the term a lot, but what is a trust? And maybe walk us through how a trust is different to owning assets in your personal name.
Okay. Yeah. When you hear the word trust, it can sort of give you anxiety and sound too complex. You might want to not think about it. But the way I like to talk about trust is that basically it's just a box or a bucket that holds assets, property, and that bucket has rules, and the rules are set out in the trust deed, and it's administered by a trustee. The trustee is basically the manager of the bucket. The trustee looks after it. Trustee has a lot of obligations. The trustee can be an individual, so a person, or more often than not, the trustee is a company with shareholders and directors who may change from time to time. And then The bucket can distribute what's within it to a class of people called beneficiaries. Those beneficiaries also can be individual people or they can be companies as well. So they're just the type of companies that hold income, and then a class of um, people that can receive the income from the bucket. It's not, which could be shareholders, yeah, other trusts as well, if we're going to get very complicated. But the trust is just a holding box or bucket. And you can have different kinds of trusts. The two main ones that we think about are unit trusts and discretionary trusts. They're a little bit different from each other. Unit trusts are more similar to a company where each unit holder has a certain number of units in the trust. So it's a certain portion of the bucket. And then discretionary trust, it's up to the trustee, the manager, as to how the beneficiaries of that trust receive income from it. And the good thing about a discretionary trust is you might want to adjust the distributions according to the individual beneficiary's tax situation. So you might give more to someone that's not working so that the higher income earner beneficiaries don't pay so much tax. It's one strategy. So yeah, lots of flexibility in that one. The beneficiaries or the unit holders can only receive in accordance with their unit share. So it's more fixed. And then when we're talking about wills and testamentary trusts, they're more than likely a discretionary trust. Yeah, that's how I like to explain it. Just making buckets.
Yeah, thank you for sharing that. So, a friend of mine recently mentioned that trust structures could save them thousands of dollars in tax. Is that true? And can you maybe give us an example of how that would work?
Yeah, so if you structure your trusts or you have the right trust in place, you can reduce your overall tax that you pay because you can put the income into the structure itself, and there's certain set rates of tax that might be less than what an individual would pay. So that's one way that people utilize trusts to reduce their taxable income. The other way is that they can reduce distributions. So the income can go into the trust and then it can be paid out to the beneficiaries in a certain proportion. And when we talk about discretionary trusts, usually people with the guidance of their accountant will look at all the beneficiaries' tax positions and then allocate the income accordingly. So cutting up the pie in the right proportion to pay the least amount of tax. And that's all perfectly fine under our tax system.
Wow, that's so interesting. You must see some really expensive mistakes in your practice. I'm guessing people get all sorts of different advice and ideas from each other and people that aren't necessarily qualified to be giving them advice, especially when it comes to tax and legal and financial. And a lot of business owners actually stay awake at night worried about what would happen to them or their families. Say if something happened to them, who would control the family trust, for example, or what would happen to their families financially. Can you maybe walk us through what actually happens when someone does have a trust in place? And if something, God forbid, was to happen to them, what would happen for their family?
Most trust deeds have mechanisms within them to account for the trustee, say, who's the manager of the trust, losing capacity. There's a process for appointing a new or substitute trustee or a caretaker trustee. And having that clause is so crucial because to have the, smooth transition and to keep maintaining the business or whatever's happening, whatever the trust is in charge of, having that backup person that can come in and step into that role is so important, keeping daily operations going. I have seen occasionally, and it's so sad and so expensive. I have seen situations where there's been no mechanism for that to take place for a substitute to set up. And then that estate has had the stress of litigation and having to go to court and ask for the appointment of a professional trustee to step in. In the end, it all worked out, but there was just a period of time where they were in limbo and the worries just piled up, bills couldn't get paid, people couldn't get their wages paid. And in that situation, the trustee was run by, and the business as well, was run by one person, one director, and one shareholder. So there was no one else. And we had to get the court to appoint somebody. And that person was very successful with a really great company. I think they had something like 20 plus employees all over Australia, and that, so worried. Everyone was worried about where their next mortgage payment was going to come. Yeah. It worked out in the end, but if he had sought the correct advice and had a backup plan, it could have been so much easier.
So what happens if like there was a case where someone's father's will said one thing, but their super went somewhere completely different? Is that something that's common where there's a conflict between a will and a super nomination?
What I see normally is that the nomination has expired, or the nomination is to somebody individual rather than the legal personal representative. That's what we call it in New South Wales. Basically, that is where you nominate your super to go to the executor of your estate. So if you do that, then the binding nomination causes the trustee of the superannuation to put all your super into the estate, just like all the other assets. But normally, super sits outside of your estate. It's more easily accessible for your beneficiaries. And, that's for good reason. You might need your funeral paid really quickly, and the super money can be accessed for that. So if the binding nomination is done correctly, the trustee of the super cannot go against it. It has to be done that way. But more often than not, I see that the nominations are expired, or they've nominated a sibling or a specific person, and then that causes the person receiving super to have to pay tax like ordinary, like getting income, so at a higher rate. Whereas if it's going to the spouse or to the legal personal representative, it's not, tax isn't paid in the same way. Then in wills, I sometimes see, like you say, yes, a conflict. The will says it goes to this person, and that could be because the will is older or more recently made than the nomination. So where there's a conflict, it creates chaos. And sometimes I think a lot of people's super is really significant. People are holding, I think there's a lot of research at the moment, just how it's like $1 billion industry. Second to maybe the family home, super is one of the best tools people are using to create wealth. And so why people don't do the binding nomination correctly, I don't know. It's usually a one pager. um, but again, the legislation has changed recently, and it's always changing. And I remember at one time when I was a baby lawyer, I think they operated one and done. Then they were every 2 years and every 3 years. And I just say to my clients, keep an eye on it, maybe make a calendar alert if it's going to expire soon, and have a look at it again. But also, a lot of times I advise clients to, whatever you've put in your binding nomination, if that's what you really want, maybe your will should also reflect it too. So it gives your executor more wiggle room, and prevents conflict and having that situation where someone's paying too much tax, or the wrong beneficiary is going to get the benefit of not only your super fund too. The nomination allows the beneficiary of that to receive your death benefit. So sometimes there's an insurance component to a super fund, which can be equal to the amount that's in there. So lots of benefit to getting that right.
Absolutely. It seems like these things, there are lots of traps, and sometimes people don't think about these things until things go wrong.
Yeah.
I've heard about a couple who had their entire retirement mapped out perfectly, but then when the husband passed away, the wife lost access to half her income streams. So that's definitely very scary. And there are a lot of people that are not aware of these things. It's too complicated. It's not something that they want to look at or think about. And I'm guessing, as I mentioned before, that you've seen some pretty expensive mistakes in your practice.
Yes. With the super as well. Like very often now, if it's not a self-managed fund, if you've got a commercial retail fund, industry fund, it's just a matter of logging in and pressing. You don't even have to do an actual form these days with a lot of funds. So something that, the listeners can have a look at today if they haven't done that before.
Yeah, fantastic. Thank you. That's really good advice. Because, yeah, not a lot of people understand super. And from a legal perspective, there must be massive blind spots.
Especially with divorced people, they sometimes still have their ex nominated. It's
Oh,
exactly not
gosh.
what they want.
Yeah, I've heard some horror stories. I've even had a friend who, after living with their spouse, who they weren't married with, for a number of years, their spouse has been able to take them to court and she now owes him even half of her super. Is that possible to mitigate through like a prenup? Or what can people do, especially, for those people that are listening who are young like me and they're moving in with their partners, their fiancés, or even their boyfriend, girlfriend. And is it really true that after 6 months, someone can be that vulnerable to the other person, taking even things like their super?
In family law, superannuation does form part of the joint asset pool, whether you're married or whether you're de factos in certain circumstances. And that's why I always recommend to clients getting engaged to think about it's not very romantic, but it's definitely a smart thing to do is to think about what would happen if we break up. And it's the same with business. Having succession plans is like if we exit, what will happen? And the same for relationships. Okay, so if you're a savvy person and I think if you have a partner that respects you as well, then they won't be offended by having these sort of discussions. I'll also encourage people to maintain financial separation, but from day one if they can. That just makes life easier. So we can say, I contributed this, I contributed that. But a prenuptial or a binding financial agreement, as we call them in Australia, it's such an important document. It sets the tone and it also can say to your partner that, we might not always get along. And if down the track we don't get along, this is what we're going to do with our assets. These are the things I'm bringing to the relationship financially, and these are the things I want to take when I leave. And it's clear, it's transparent, there's no confusion. And I think with the bank of mum and dad too, a lot of kids are receiving generous gifts or loans from their parents, and it wouldn't be fair for their partner to receive that in the event that they broke down, if their relationship broke down. So it's great to have a BFA. It does require, both people to have lawyers to give them advice and look at the document and make sure it complies. But I mean, it's the same with getting into a business venture, it's just doing your due diligence actually. Yeah.
Yeah, the way you put it, you've made it so crystal clear what a prenup is. I think people have different ideas of what it is, but I like the way you've simplified it. It's like, this is what I bring in, and this is what I want to take with me if things don't, if things go south. So that's really interesting. I recently learned, going back to the topic of super, that leaving super to your adult children versus your spouse has different tax implications.
Mhm.
Is that true? And is that something that people know about?
I don't think people do know about that actually, and that's why it's like so key. Like when we are talking about the binding nomination and your will, making sure that your super is going to who you want it to go to, that you nominate the right person. Yeah, spouses and your executor, your legal personal representative, don't pay the same tax rate. But if you nominate children, your siblings, cousins, parents even, then you're really making it harder for them to receive full benefit, okay? Because they're going to be paying tax on that gift, on that inheritance. And I don't think that when people make those nominations, they realize that they're doing that. And it's probably not the intention of the person making that nomination. I think no one wants their beneficiaries to receive 30% less or whatever their tax rate might be. than the amount that is there.
I've also heard a lot of business owners joke about dying at their desk because they've got no exit plan. What are some conversations that business owners should be having with their solicitor years before retirement?
Yeah, I think in the same way like what we spoke about with the binding financial agreement, I think business owners need to have a look at their business and think it's smart in the sense that they can sell their business at some point and they might want to do that. But they need to think about if I'm not running this show, who else is going to do it? Does anyone else want to do it? And then they might start thinking about planning their business around that. They might need to change the constitution of their company, say, or the policies and procedures. But it's always smart to have an exit strategy, right? And like, why am I growing this thing? Do I want to be working forever? Some people really love it. That might be what they want to do. But I think there's value in having an exit plan because you can say, if I get hit by a bus tomorrow, this is what should happen. I want this person to be the manager. I want these people to be board of directors. This is what my business stands for. And having a plan, you can address all of those. We've actually done this for companies that are multinational as well. So it can be that complex or it can be really simple. Family business, you might want to say, well, these are the kinds of people that we want to work. We've already earmarked these people to take over. And this might be what their salary involves or the shit they might get shares, all sorts of things that can be put into that document. And it's also a good document to start. It might not be perfect, but it's an evolving thing.
Yeah.
Otherwise, you might end up dying at the desk. Oh my goodness.
Yeah. So, speaking of which, people also talk about power of attorney. And you've just talked about how a business owner can prepare their business before they get to a stage where they die at their desk, so to speak. What is a power of attorney? And also, what's the difference between a general and enduring power of attorney, and why does that matter?
Okay, so a power of attorney is a document that gives a principal the power to allocate a decision maker for their financial, we'll talk about it in financial terms, financial decisions. So that person can step in and operate bank accounts, can sell property, can lease property on your behalf, can do all sorts of things. The document can set out the powers. General is just usually for a shorter period of time in only limited circumstances. And enduring is one and done, like it's forever until it's revoked. So you might have a general attorney to cover a period where you're going overseas for a holiday. You might be going for 6 months. And so you might put it in place for this certain period of time and then it goes away. An enduring power of attorney is usually long term, and usually people will put that in place for more for their personal financial situation. And another kind of power of attorney I would like listeners to think about is a corporate power of attorney. So that's the kind of power of attorney you would put in place for someone to make decisions about your business if you lose capacity. So
Mm.
they, yeah. And I've seen so many business owners neglect that document. And like I said before, it just leads to litigation and all sorts of heartbreak, really, and costs. And again, maybe a 1 or 2 page document, and you can save so much money and time. Yeah.
Mm. For the SMSF trustees that are listening, I've heard that this document is quite make or break. Is that so? Is that something that's very critical for them specifically?
Yeah, so a self-managed super fund can have members, right? And usually those members are also the shareholders of the trustee company that manages it. And so the members from time to time meet together and they have financial strategy meetings about the direction of the super fund. And from time to time, I mean, people can lose capacity, the individual members. So most self-managed super fund trustees will have a mechanism where someone can step in the role of trustee or director for that member when they lose capacity, but they can still hold on to their share. And yeah, so having that in your trustee is so important because so many super funds are controlling lots and lots of assets, and you need somebody that can make decisions quickly. And that's why, yes, power of attorney could be useful for that structure too. But I also would say look at the deed too. That should work together.
If you could guarantee that every Australian had just one legal document or structure in place before retirement, what do you think would be that one piece of document that would save the most heartache?
I think a will, honestly, a will that represents your wishes, that has all of the children that that you have in it. A lot of times people will get a will done, soon after they get married or after the birth of their first child, or they buy their first property and then they forget about it. They might have had many more kids since then or grandchildren even. So I think I would like people to get a will, but also look at it regularly. And when I say regularly, like maybe every 5 or 10 years, to me that's not very often. It comes around before you know it. Time. We never know when it's our time. So if keep an eye on it. Very often, like I have seen wills that have been drafted many, many years ago and they're perfectly fine because they've been done by a professional. And yeah, so I think spending a little time and a little effort and having those discussions with your solicitor will just make it so stress free for your family. And nobody wants to be fighting about their inheritance or arguing with an executor when the time comes. They just want to, make the funeral arrangements, have that grieving moment, and when the time is right, distribute the estate in a fair way. And you can achieve all of that in a well drafted will.
Wow, you have shared so much wisdom with us today, Peter, and I am so thankful for all your knowledge and expertise. We've talked about retirement, we've talked about protecting ourselves, we've talked about super and some legal considerations, trusts and asset protection. Could you please share with us, is there a closing thought or one piece of advice that would fundamentally change how we can protect our future, whether it's our business, our family, or ourselves or our partners? What's one piece of final thought that you could share with us today, Peter?
I think the final thought I'd like to share is that it's so important to plan. And if we, fail to prepare, then prepare to fail. And if we really love your family or your loved ones, then a lot of people have a superstition about getting their estate planning done. They think if they do it, it sort of leads inevitable. But I think if you really care about what you've built and what you've got, and you want the right people to get it, then it's a form of love to get your documents in order to take that burden away from your family.
I love that you mentioned that it's a form of love, not only for your family, but also for yourself as well, just that peace of mind.
Peace of
So,
mind, yeah. Do it
yes.
once, forget about it.
Yeah, yeah. Is that something that can get lost? Like if the family don't know where it is, then what happens?
Yes, well, in my practice, I generally ask the clients, would you like me to make some certified copies for your beneficiaries or for your accountant or your financial planner? And more often than not, they say yes. So that,
Mm.
if the original will does get lost or if there's a flood, then people will have copies. And yeah, that's a service we offer too.
Is that something that can be held digitally? Can the children go to the lawyer of the person that's passed away and request that?
Yes, a lot of us are moving towards storing our files in the cloud now. So yeah,
Yeah.
that's quite common. Yeah.
Yeah, wonderful. Well, Paisa, it's been a great conversation. Thank you so much once again for your wisdom. And to the listeners, if you have any questions at all, please don't hesitate to reach out to Peter. I have all of her information in the show notes. You can obviously connect with her either via LinkedIn or via email. And of course, the hdlawservices.com.au website. And Peita, once again, thank you so much for joining us on this show today and for everything that you've shared with us.
No,
It's been
thank
a
you very
pleasure.
much. It's been fun.
Yeah, and it's been a pleasure having you, and I hope we'll speak again soon.
You too. Thank you so much.
So thanks for tuning in, and I look forward to seeing you inspired to thrive.